Today we are looking at a key piece of legislation that continues to shape the United Kingdom's immigration system, the Immigration Act 2014. The law was approved in May and introduced 77 separate provisions aimed at reforming how immigration is managed in the United Kingdom. According to the government at the time, the objective was to create a system that was fairer to British citizens and legal migrants, while becoming more robust again, those without the right to remain in the country. The act was developed through cooperation between the Home Office, other government departments, developed administrations, and the Crown. It was presented as a continuation of winded efforts to reduce net migrations and others what the government described as abusive practice within the system. At the time, the Secretary of State for Immigration stated that the legislation marked a turning point in immigration reform with a focus on ensuring that the system worked in the national interest. He also confirmed that implementation would be prioritized to ensure the measures were introduced quickly and effectively. The reform introduced by the Immigration Act 2040 can be broadly divided in two main areas. The first area focuses on restricting access to service for those without legal immigration status. Under the Act, temporary visitors were required to contribute financially toward the cost of accessing the National Health Service. The legislation also placed new responsibility on landlords requirement, requiring them to check the immigration status of tenants in order to restrict access to rented accommodation for individuals without the right to remain. In addition, the act aimed to prevent individuals without lawful residence from obtaining a driving license or opening a bank account. Bank and licensing authorities were required to verify the immigration status of applicants, and driving license could be revoked if a person overstayed their legal permission to remain in the UK. The second area of reform relates to enforcement and deportation. The Act introduced measures designed to prevent the misuse of the immigration system through marriage or civil partnership of convenience. It also significantly reduced the number of appeal routes available against deportation decisions, cutting them from 17 to 4. In case where there was no rise of irreversible harm, the law allowed for individuals to be deported first. With appeal considered after removal, the legislation also made it easier for authorities to recover unpaid civil penalties linked to immigration breaches. Another notable provision requires courts to give greater weight to Parliament's view of the public interest when dealing with immigration cases involving Article 8 of the European Convention of Human Rights, which relate to respect for private and family life. The Act clarified that the right to family life shall not be treated as absolute in immigration decisions. Finally, the legislation restricts the ability of individuals to make repeated applications for bail, limiting what the government described as unnecessary delays in its enforcement. In summary, the Immigration Act 2014 represented a significant shift toward tighter controls, greater enforcement power, and reduced access to service for those without legal status. Supporters argued that it strengthened the integrity of the system, while critics raised concerns about its impact on access to justice and everyday life. More than a decade later, The Act remains a key reference point in ongoing debates about immigration, enforcement, and the balance between control and fairness in the UK.